The President has issued a detailed statement assuring South Africans that his CR17 election campaign was above board. The Presidency says the campaign was conducted in a clean and ethical manner and within the prescripts of the law. To talk to, we spoke earlier, to talk to us more about the developments of the President's and the Public Protector's legal wrangle is law expert and attorney Ulrich Roux. Good morning, Ulrich. Thank you so much for taking the time to join us this morning. Your initial thoughts about this wrangling, this back and forth?
Well, unfortunately, it's just another legal battle in our courts that the Public Protector has become involved in. The President is alleging that all the information which has now been included in her Busata report is above board, and that certain of the bank accounts that have been attached to the report have been obtained in an unlawful manner. And if that is the case, then certainly it's another blow to the Public Protector's integrity. But one would now have to wait and see what the court makes of his application. So the President has now approached the court to keep the so-called bank statements, which he claims have been obtained unlawfully, secretive, so that it's not open to the public and for everyone to see.
Eyebrows were raised when reports came out of the President approaching the court, as you say, and with some wanting to know what he has to hide. But others are saying it's about the right to privacy. What are your thoughts here?
No, certainly the right to privacy is a constitutionally enshrined right, and obviously if bank statements have been obtained in an unlawful manner, then they are inadmissible. Having said that, the counter argument to that is that if the President has nothing to hide, then why is he bringing an application for these documents not to be disclosed to the public? And that is obviously his argument, is that it is people's privacy. It's not lawful for their private documents and the bank statements to be disclosed to the public, and one would have to wait and see whether the High Court finds that there is merit in that application. Obviously, if the bank statements were obtained in a lawful manner, then they will be fully admissible and they will be disclosed to the public. So one would have to wait and see whether the President will be able to prove that it was obtained in an unlawful way.
Is it worth pursuing whether the President did everything above board or not? What do the people who are pursuing this matter, what do they hope to gain?
Well, it is the DA and the EFF who have approached the courts to say that, well, it seems as if there are some eyebrows that need to be raised pertaining to the funding of the President's presidential campaign and his election campaign. So obviously they have a lot to gain by it from a political point of view. But there are rules and regulations that political parties need to comply with, and the IEC makes it clear what those regulations are pertaining to funding of election campaigns and what it needs to comply with. And if it hasn't complied with that, then unfortunately the President and any other political party who don't comply with these regulations and laws, will be acting in an unlawful manner.
Just from a glance, from a legal point of view, is there anything worth investigating in the way that the President was funded?
Well, once again, these election campaigns must comply with all of the laws enshrined in our Electoral Act, and if it doesn't, then it's unlawful. It's as easy as that. And one would have to wait and see whether the President did comply with that. One would have expected all his advisors and him himself, when you do run an elected campaign, everything is scrutinized by your opposition, and everything should be transparent and out in the open. Anything that is hidden and that is done in a secretive manner or in a manner that is not in line with the Electoral Act will certainly be scrutinized and could come back later to bite the President, and cause great damage both to his credibility as well as his electoral campaign. So I must say that I would be surprised if anything does come out to show that there was any untoward behavior by his team. It's just because of that fact. He has advisors and he has an entire team who ensures that everything is above board and that they comply with the Act. So I would be surprised if, in fact, anything comes out that shows that they did not.
So the request by the president for the courts to not reveal some of the information in these illegally obtained documents, do you think this will succeed?
Yes, certainly. So in our law, you have the notion of fruit of a poison tree. So what that means is that if something was obtained unlawfully or it has been included in the Public Protector's report and it should not have been, then any results or any findings made on those illegally obtained documents is not lawful. So it cannot be used, it cannot be relied upon, and it certainly cannot be used in the Public Protector's report when she makes recommendations. So there's definitely merit in the application for the President, and that is it. You need to protect people's right to privacy, and you need to ensure that if information has been obtained unlawfully, that it must be stopped immediately and that no adverse findings be made upon it. Again, as I said earlier, the converse to that and the argument against that is that, well, Mr. President, if you have nothing to hide, then why not just disclose the bank statement? Then the argument of the right to privacy then obviously comes back. So it is a good legal question to be asked, and hopefully the courts will be providing clarity pertaining to it.
The Public Protector Advocate Busisiwe Mkhwebane is a legal practitioner. Why do you think she would miss the point about the unlawfulness of exposing private personal details?
Well, she would obviously now argue that it was not obtained unlawfully and that she was fully within her right to include the bank statement. But as you say, one would expect a legally qualified person to make sure that whatever document she relies upon in her reports has been obtained lawfully and cannot contribute towards the credibility of the report being brought into scrutiny. But having said that, as I said earlier, unfortunately, our Public Protector has found herself in numerous court battles of late, and it is not a favorable situation. You want your Public Protector to be out there and to be doing her job and not having to defend every single report that she brings out in court. Unfortunately, she has lost a number of legal battles. The first in the ABSA Bancorp matter, where she had costs awarded against in a personal capacity. And then she also lost the two most recent applications to High Court, both by Minister Pravin Gordhan as well as the President. One will have to start questioning the advice that she's receiving, because, as I said, it's not a favorable situation for her to be embattled in court litigation the entire time. She should be out there doing her job.
In every sector of society, there are what you call case studies. Outside of the courts, in the legal fraternity, what kind of conversations are taking place regarding all these cases that the Public Protector has been involved in? Is there a sense, like some of the court judgments have said, that she doesn't have a full understanding of her work, or are there quarters that feel there is a point to what she's doing?
I think where we stand at the moment, unfortunately, there's a big political stigma to the Public Protector at the moment. If one had to look at the position holistically, it obviously is clear that the EFF is backing the Public Protector in whatever she is doing, and they obviously have a strategy pertaining to this. They want to bring some of the ministers and the cabinet members into disrepute, as well as the President. And if they can support the Public Protector in applications, then they will certainly do so. There is a political motivation behind that. But having said that, certainly in the legal circles that we find ourselves in, when people talk about this, unfortunately, all we see is the losses that she is suffering in our courts at the moment. And, that is all that we can really base our opinion on, to be honest. The day that she does win one of these applications in court, then obviously your viewpoint surrounding that would differ. But we need to have faith in our judicial system. We need to have faith in the decisions of our courts and our judges. And up until now, unfortunately, the public protector has suffered numerous losses. So until that changes, I think everyone is going to take the reports, with a pinch of salt. And certainly, her opinion at this stage has been brought into great disrepute.
We have in this situation two arms of the law, the judiciary being questioned and the work of government being questioned. But we also have the public sentiment, South Africans who are not knowing what to do about all these revelations, who to trust. What can we say to South Africans about how they can engage with this conversation about the president versus the public protector?
I think that our separation of powers doctrine still rings true in South Africa. Remember, that is where the judiciary is independent from the police, and that is independent from the prosecution as well as the public protector. Remember, the public protector is a completely independent body and should be objective at all costs. I think that the difficulty that the current public protector is also facing is that her predecessor certainly, instilled a lot of confidence in the society, and her findings, especially pertaining to matters such as Kandla, brought about a change in the respect that society has for the public protector. Prior to Thuli Madonsela, the public protector, I think, was seen as a bit of a toothless entity and organization, and the work that Thuli Madonsela put in certainly set the bar and raised the standard pertaining to the public protector's office, and those are difficult shoes to fill for Bosisiwe and Kobane, and hopefully as time goes on, she will prove that she is a worthy public protector. But at this stage, her position certainly is being scrutinized tremendously, and there's obviously been numerous calls for her to have to vacate her position as a public protector. But one would have to wait and see, what comes out in all these applications. If it is found that she really is not qualified and capable of doing the job, then it would be better to replace her earlier rather than later, in my opinion. But there's been no successful application in that regard, and up until that point, unfortunately, people can say what they want about her, but she is a public protector at this stage. And she is the head of an organization that has garnered a lot of respect in the past in South Africa, and hopefully we can restore that respect and have respect for the position of the public protector, who fulfills an extremely important role in ensuring that government and state organizations are taken to task if there's any corruption or any unlawful behavior taking place.
Thank you so much for making the time to talk to us this morning from Ulrich Roux Associates, Advocate Ulrich Roux.